Okay, we'll now hear from counsel in the next case, Orange County Fire Rescue and Unisource versus Jones.
Thank you very much, Your Honor. May it please this honorable court, my name is Lamar Oxford, and I am the appellate attorney for Orange County Fire and Rescue. And with this oral argument, we leave the world of banking and go back to this court's favorite area of the law, workers' compensation. But in that context, I respectfully submit that although this is the area of occupational disease and hepatitis, hypertension, an area that the court has issued many opinions on, we would respectfully submit that the issue here is pretty cut and dried. Although it's certainly affected by this court's in-bank opinion just last month in Sadaka, which, for reasons I will explain, we believe are helpful to the arguments that we've made in this case. But let me briefly summarize the facts again for you because they are key. This fireman got hepatitis C in 1992. Pre-Bartlett, pre-Flamley, pre the Center for Disease Control saying that firemen aren't exposed to hepatitis more than members of the general public. In 1992, he gets hepatitis C. He can't prove that it's specifically caused by his employment, but under the law at the time, Orange County Fire and Rescue accepted as compensable. Hepatitis C, not high blood pressure, not a condition that can come and go, a disease that while it may not show symptoms on some occasion, it is undisputed in this case that by his own physician that it is a disease that never goes away and will come back and will progress. I failed to mention that this appeal comes before you on completely undisputed facts, so I assume you can give it de novo review. This gentleman contracts hepatitis C in 1992. We accept it, we pay for his treatment, and we pay TTD at the time for a few months of that treatment, and then he returns to full-time work as a fireman. He still has hepatitis C, but he's able to go back to work.
Was there a wage loss at that point, does the record reflect?
Temporary, yes, sir.
So there was some wage loss?
He was paid a few months of TTD, yes, sir. And then 5 years later, his hepatitis C has progressed to the point where his doctor says, you need significant treatment, interferon. He finally agrees. And in 97, the same thing happens. He has to leave work because of the treatment for his the same hepatitis C, and we pay him all the medical, which we've been paying all along. He's been going to see the doctor yearly, so there's no statute of limitations issue. We pay the medical, and we pay the few months of temporary total disability that he's off work again. And as doctor said, no new contraction of the disease, no new needle stick, no new incident, no new accident. His own doctor
changes, the statute changed.
It does. But let me, if you don't mind, let me finish real briefly. The same thing happens essentially in 97 that happened in 92, and then he goes back to full-time work as a fireman. Now here, I think, is a lynch point. 8 years later, after Michaels, I think, is really the key to the claimant's bar's endless creativity. 8 years later, he and his attorney file a claim in 05 that says, oh yeah, that brief period of time that I was out of work in 97 for treatment for the same condition I've had since 92 was a new date of accident. And under the 94 changes, despite the fact that...
As you've told us, there is no statute of limitations issue, though.
No, sir. No, sir. There's one incident, or one contraction, one acceptance of compensability, all in 92, payment of benefits, full-time work. 5 years later, in 97, there's treatment that takes him out of work temporarily. We pay the benefits. And then 8 years later, they come along and say, 97 was a new date of accident, so now we're entitled to thousands of dollars.
Well, Mr. Oxford, what this case really comes down to
permanent impairment.
is we have an occupational disease here because that's been conceded. And the question is whether or not there is a new presumed date of accident. Now we know from Sadaka that the combination of an occupational disease and a disablement as manifested by wage loss creates a date of accident
Yes, sir.
under the statute. So the question is, after that disablement, period of wage loss, when that same employee goes back to the same job and works again, and then later suffers an additional period of disablement and wage loss, whether there is effectively a new date of accident. Isn't that really what this case is about?
That's it in a nutshell. Now, you know a whole lot more about Sadaka than I do. I've read it several times.
You probably shouldn't count on
No, I wouldn't count on that at all.
on any of us knowing more about it than you.
Well, my point from Sadaka is that it appears the court is now saying in Sadaka, and using prior precedent, I don't mean it's a brand new decision, that you've got to prove a permanent incapacity to work, to have true disablement. That's what Judge Webster disagreed with, but the 10-5 majority appeared to find whether it be a partial permanent incapacity or a total permanent incapacity, as in Michael's. In order to have disablement under the statute, you need to have an incapacity to do this job.
And that's
this guy went
demonstrated
back.
by wage loss. That's demonstrated by wage loss.
Yes, sir.
And wage loss occurred in this case prior to 1994.
No question about it.
And again in 97.
That's right. For the same condition. Not hypertension that comes and goes.
Well, I know, but see, the thing that you're doing here, and this is the problem that I have in thinking my way through this case, and I'll just share it with you.
Yes, sir.
All of these occupational disease cases are really, they're just founded on theory. And the theory is, as I understand it, and you may very well understand a lot more about this than I do, but the theory, the theoretical underpinnings is that there's something about that work that causes employees in that work to get certain types of diseases, to get the diseases and perhaps for those diseases to get worse. Now, that's a real easy kind of a thing to follow if you're talking about maybe something that's being inhaled on the job and you get interstitial lung disease. It's even easier to understand, I think, in a situation where you're talking about heart disease.
I agree.
Because that progresses.
Right.
Well, what it seems to me that you're trying to do here is to draw a distinction between those type situations and contracting hepatitis C. I guess if this guy got it on the job, he must have been pricked by a needle somewhere, sometime along the way. And once he was pricked and had the disease, your view is that's it.
Yes, and, of course, as you know, there's absolutely no evidence. In fact, this guy admitted that I never got pricked, to my knowledge. Now, in 92...
But it really doesn't matter.
In 92, we thought it didn't matter. But we're contesting a 97 date of accident. And, I think that you should reverse under either of two ways.
Okay.
Either there's no 97 date of accident because we accepted it in 92 and it's the exact same disease, and all 97 was more treatment for the same thing. Or, under Sadaka, you can find that there's no 97 date of accident because there's no disablement here.
Well,
and there's no proof
of
of
it.
it.
But he didn't have any wage loss in 97.
Only temporary, which we paid.
Oh, he did have it in 97.
Oh, I'm sorry
too.
if I misconstrued your...
6 months out, right?
Yeah, he was out a few
Yeah,
months,
this
like he had
interferon
been
was
in
tearing him
92.
up. So, I mean, he was out of work for a long time.
But in Sadaka, you said that the prong of the occupational disease is not meant because he does not have apparently permanent loss of wage earning
Well, I
capacity.
mean, you're just kind of making that up, right? It doesn't say permanent. In fact,
Yeah, it really does. It says permanent partial or permanent total loss of wage earning capacity.
I can read it to you, Your Honor. I mean,
It's at the very end
I
of the
brought it up
majority
here.
opinion.
There's several quotes from Sadaka that I think are pertinent to this appeal here, including one that Judge Webster made in the dissent that I don't think I don't think the majority would disagree with. It's just really a point of law. This has to do, of course, in this case, we're talking about permanent impairment benefits that they're seeking long after the fact, based upon a change in the law that occurred after the date that his hepatitis was accepted as compensable. But you're talking about pre-93. In all other cases of permanent impairment, the claimant had to seek wage loss benefits, which were based on actual wage loss. Thus, except in very limited circumstances, a permanent impairment was not sufficient to entitle an injured worker to benefits unless there was evidence of actual loss of earning capacity, which is slightly different than actual loss of wages. This guy had actual loss of wages temporarily in 92 and 97. We paid him. He's never proven loss of wage earning capacity. He's working full-time today, and that's our whole point here. So we contested a 97 date of accident, not only because we believe that there's any date of accident at all, it's 92, and we've paid complete and full benefits for medically and temporary disability, but also because under SEDACA, for a 97 date of accident, he can't meet all the prongs, all the requirements. The fireman can't even prove anymore. The Center for Disease Control has confirmed that Bartlett and Flamley, that, there's no greater incidence of hepatitis.
So your interpretation of SEDACA is that a temporary disability conceitedly attributable to an occupational disease does not entitle the claimant to temporary disability benefits.
I may have to do it on rebuttal, but I can come back here with quotes from SEDACA that certainly suggest that.
Well, but SEDACA doesn't deal with temporary disability benefits at all. It deals with impairment benefits.
Exactly, which is what this case, of course, deals with, which I would respectfully submit as a bonus. They're looking for 8 years after the fact. In 05, they filed a claim for a new date of accident in 97, seeking a bonus payment because we've paid this gentleman everything he was entitled to. And now, despite the fact that he continues to work full-time...
But the 8 years after the fact is a catchy phrase, but you've been giving him medicals along. There is no
statute of limitations
issue.
I'm sort of pointing out that, which I think would make the legislature roll over in their chairs, the creativity of the claimant's bar. They're using Michaels, which ought to be strictly limited to its facts, and which clearly involves a permanent total disability, but an average weekly wage issue. And they're trying to turn it into a situation where every full-time working fireman who happens to have hepatitis and been paid some benefits before can now get a bonus payment of permanent impairment benefits.
Well, and this was a substantive change in the law, so unless they can show a new accident, a new date of accident, they don't get the benefit of it.
No, sir, that's exactly right. In 92,
and that's the key here.
That's right. In 92, they get wage loss, which the Supreme Court said is ultimately fair. The founding principle of compensation, if you have wage loss because of an injury on the job or an occupational disease.
Well, it comes back to Judge Allen's question. Can you have multiple dates of accident?
Well, allow me to carry that. In some circumstances, you can. But let's carry out the logic to its extreme, which we can't deny the truth of the extreme. Interferon treatments are used on hepatitis C patients constantly. You can have, the doctors have said, 5 a year. Let's say this guy goes for 7 years with interferon treatments, and he's out a few weeks or a couple of months every time. Is he going to have 35 new dates of accident? That cannot be the intent of the legislature or this court. But that's the logic of this holding here. And by the way,
well, would that be entirely inconsistent with I hate to keep coming back to this theory behind this occupational disease, that there's something about this job that is precipitating this condition. And now it would be very simple for me to accept the argument you're making if he had not gone back to that same job again. Now, I know you're saying, well, rationally, the fact that he went back to work as a fireman had nothing to do with his hepatitis C situation. But isn't the assumption that all of this occupational disease theory is based on that the job does have something to do with it?
Right, the last injurious exposure.
Yes, sir. But you've got to look at the general principle that you're talking about, Judge Allen, and then apply it to the facts. What you're talking about, the stresses of being a fireman, for instance, may very well affect hypertension and perhaps this lung disease, interstitial, that you were talking about. But this is hepatitis. And his own doctor said, You get it once, and it never goes away, and there's no evidence in this case or any other I've ever handled that shows that going back to work makes your hepatitis worse. Stress doesn't affect hepatitis, to my knowledge, and there's certainly no proof of it here. So while the general principle may very well apply to a hypertension type case, it shouldn't apply to hepatitis, and I don't think that's something for the legislature to change the law, because you and I are talking about underlying principles, not the exact language of the statute. But we're all here looking for fairness, and this gentleman has been paid everything. Long after the fact, he decided to seek a bonus with the help of his counsel. If he's got any compensable date of accident under SEDACA, it's 92. It's hepatitis. We've paid all the benefits, and we respectfully submit that the judge went too far. And by the way, in doing so, the judge said some things that I may talk about in rebuttal briefly that obviously contradicts SEDACA, which came long after his decision.
Well, actually, you don't have any rebuttal time left, but we'll let you have about a minute and a half for rebuttal, and we'll add about a minute and a half on the other side. So we'll put 16 and a half minutes on for the FLE.
Thank you, Judge Allen. Sorry I went on.
It's all right. We had a lot of questions. It's an interesting case.
Good morning. May it please the Court. Todd Sanders on behalf of the claimant Robert Jones. Judge Benton brought up an interesting point. That 8 years number really sounds very interesting. Well, let's look at the record. Back in 1997, the adjuster for the employer carrier sent a letter to Dr. Sanchez, and one of the questions she wrote or asked in that letter was, is this guy at MMI, and does he have a permanent impairment rating? Now, why would she be asking that question if they didn't think that perhaps now Mr. Jones has had a second date of accident under long-standing law?
She's not trained in the law. I mean, the whole issue here is it's a simple issue that's made difficult by the facts. The issue is it proper to have multiple dates of accident in occupational disease cases? Because, you get a disease, once you got it, you got it. It doesn't go away and then come back. It may get worse, it may get better, but if by definition a disease is something you get. But for the fact that the legislature changed the law in 1994, creating permanent impairment benefits, a dramatic change in the law at that time, but for that fact, we wouldn't be here.
Well, Your Honor, first, let's put this in perspective. What they're trying to say now, for the first time, or last year during the trial, is that this guy doesn't have an occupational disease anymore. He had one in 1992. Otherwise, what did he have?
But he didn't argue that here today.
No, it's all over the brief, and all of a sudden now the argument has changed.
Today.
What they're asking for is two decisions that came down 25 years after they accepted compensability of an occupational disease. They're asking this court to declare that henceforth and forever, hepatitis C is not and cannot be an occupational disease, even though in those two cases, compensability was the issue. It's not the issue here. SEDACA, and this court did the best it could with what we think is an archaic statute, and it may be time for the legislature to change it. Under occupational disease, you get a disease from your job, but you don't get workers' comp coverage until you become disabled. Now, in any other case, the goal is give treatment and get the person back to work as soon as possible. Under occupational disease is get the disease, leave it alone, then become disabled, and then you get coverage under workers' compensation. We feel that SEDACA, again, the court did the best it could, but to answer your question, yes, there are multiple dates of accident. That's what Michael said, and that's what McArdle said.
But Michael doesn't say it in this context. In fairness, that's a very different factual situation.
It is, and it's remarkably similar, because what happened in Michael's was when he became disabled again, when he became a second time. Remember, he had multiple periods of time where he was provided with indemnity benefits, wage loss, because he was disabled temporarily. It just so happened in Michael's that the last period of disability turned out to be permanent, but he got a higher average weekly wage based on a new date of accident. He could not have gotten that higher AWW if he didn't have a new date of accident. Sedaka upheld Michaels. They are asking this court to address Michaels and in their brief suggest that maybe it's time to recede in whole or in part from Michaels.
Or to limit it to its facts.
Based upon this court's extensive discussion of and reliance on Michaels and Sedaka, it would appear that at least a majority of the court declined that invitation. This court also in Sedaka upheld McCarter. It cited to McCarter twice. McCarter had a period of time where, a situation where you had a claimant with 2 new dates of accident and 2 new periods of disability. This court went over and over and over again in Sedaka. Wage loss is incapacity. That's the magic word, incapacity. This court did not overrule Thomas versus City of Miami, which said that the disability does not have to be permanent in order to qualify for the period of disability in which to be entitled to benefits under the statute. What they're asking now is for a sui generis disease. Hepatitis C, in their case only, was an occupational disease in 1992. Now it's not an occupational disease. I have to wonder if Mr. Jones had been advised of his rights, that he may be entitled to impairment benefits in 1997 under a new date of accident, whether they would have said, no, you don't have an occupational disease anymore. But what happened was he didn't find out about this until he got counsel in 2005. We filed a petition in August of 2005. Guess what was going on at that time? Opposing counsel's firm was litigating the Bartlett case, the decision for which came out in January of 2006. And it wasn't until 2 days before trial that they informed the trial court that, you know what, it's not an occupational disease anymore. Bartlett says so. Bartlett never said that. If Bartlett said that, then the same panel that decided Bartlett decided Flamley.
Well, you're not going to argue, I hope, that if you had to litigate this case today, you could not prove that hepatitis C is related to work as a fireman.
We never had to prove it because they accepted compensability. Maybe improvidentally, but that is the way it goes. Things change. They just happened to get lucky that Bartlett came out while the trial was, just before the trial. But he was entitled to benefits as of the 1997 date of accident. If we take Sedaka,
if there is a 1997 accident.
Well, based on Sedaka, there is a 1997 date of accident. He was disabled for 3 months, maybe even 4, as a result of his condition. So if anything, he didn't have a 1992 date of accident. He had a 1997 date of accident, and his substantive rights were determined by that. So we can call it a new accident, or we can call it the first accident.
Well, he lost wages in 1992, did he not?
Yes, he did.
So he did have an accident under Sedaka in 1992.
Because they accepted it as compensable and paid him, yes, Your Honor. And he also lost wages in 1997, and for a significantly longer period of time, I might add. And under Sedaka, which again upheld Michaels, and perhaps more importantly, upheld McCarter.
But it doesn't address either of those cases in the context we're talking about here today, about multiple accident dates. It uses them to justify the proposition that you actually have to have wage loss before you have a disablement.
And Mr. Jones did. He had a wage loss. He was paid temporary total disability benefits. And remember, McCarter specifically said that just because an employer decides to pay full wages while the person is out of work because of his condition doesn't mean that he was incapacitated from earning, and the key word is from earning, his normal wages from his occupation.
Well, now, McCarter indicates that there was an ensuing period of disablement, but does it really indicate that there was a second accident?
Well, that wasn't the issue in that case, and that's why they didn't say straight out, this is a new accident.
Well, I don't think that there would be any dispute between you and your opposing counsel about there having been 2 periods of disablement here. The question is whether or not there are 2 accidents.
But under the law, and again, occupational disease and the statute, it's got the whole system upside down. But that's not our fault. And this court basically said in Sedaka that periods of disablement. And then Flamley, more importantly, they said that the
It's
court...
been suggested that SEDACA says periods of permanent or a permanent disablement is required.
No, Your Honor, because otherwise they would have just overruled or reversed Thomas versus City of Miami.
Do you have a copy of SEDACA with you?
Yes, I do, Your Honor.
Read the last 3 or 4 sentences of the majority opinion under conclusion.
Without an injury by accident, want me to start from there?
I don't have a copy with me. The very end of the opinion.
The conclusion paragraph talks about periods of incapacity resulting in actual wage loss, and without which one cannot show disablement, and without disablement, one cannot basically have a date of accident be covered by the statute. Here, we had three periods of disablement. There were 2 in the 92-93 period, and then you had a very extensive one that started in 97 and went into 98. It was like a 3 or 4 month period of disablement. And therefore, each one of those times was an accident date under occupational disease. Otherwise, in Michaels, why would Mr. Michaels have been entitled to the higher average weekly wage when he was disabled again, and although it just happened to be permanent? Why else would he have been entitled to a quote-unquote bonus of a higher average weekly wage if he couldn't have another date of accident, i.e. another period of disability? We didn't write 44151, the legislature did. And disablement is what counts for getting you coverage under occupational disease. But what they're saying here is, in this particular case, they want a sui generis condition, right? It's hepatitis C. Because we accepted compensability in 92 under occupational disease, it's no longer an occupational disease based on Bartlett, and therefore we're in the middle somewhere. We want a new category created just for us, and allows us to avoid paying impairment benefits, even though they've conceded in their brief that if Mr. Jones becomes permanently disabled, they're on the hook for that. If he doesn't have an occupational disease, and if, as they state, he cannot prove he's got one, under the 4-prong test, why haven't they denied all benefits altogether?
All right, and the permanent impairment, the statutory change we're talking about, permanent impairment benefits replace the permanent partial disability.
Yes. That's one interpretation of what the statute did, yes.
And they concede that they would be on the hook for permanent total. So the question is, why are they not?
That's one possible reason. Why are they not denying the medical treatment? And if this court does what they are asking you to do and say that hepatitis C cannot be an occupational disease, what happens to Mr. Michaels if he's still alive? Are they allowed to stop paying his benefits now because he doesn't have an occupational disease? I mean, this is a situation where they accepted compensability. They knew in 1997 he had an impairment rating. I don't know why anybody would ask about that if they didn't think that was a potential thing that they were going to have to pay. And then they wait.
You keep raising that as if for some reason, because as a matter of fact, some claims person wanted to know about impairment, that has some bearing on the outcome of this case. This is a pure question of law. The question being, was there a new accident after 1994? Because if there wasn't, clearly the permanent impairment provisions are substantive, and you're not entitled to the benefit of them unless there was a new accident in 1994.
That's absolutely correct.
And whether this claims adjuster was concerned about permanent impairment or not is utterly irrelevant to that issue.
I'll concede that, Your Honor. As far as the legal issue, yes. And what I would state that is based upon SEDACA, the family of decisions that have developed over time under this admittedly very anomalous statute, the occupational disease statute. Every period of disability creates a new date of accident and thus entitles that claimant to the substantive rights that are in effect as of the time of that accident. Again, otherwise, why would Mr. Michaels have been awarded higher average weekly wages? And this court easily could have overruled or partially reversed Michaels and SEDACA. Instead, it discussed it at length. And I would also state that, again, the panels in Bartlett and Flammley were identical, the same three judges. If Bartlett stood for the proposition that hepatitis C is not an occupational disease, all they had to do in Flammley was say hepatitis C is not an occupational disease, see Bartlett. But no, they ruled on the facts in that case. They're trying to change their position today. They're saying that, oh, wait. No, you can't have multiple accident dates when the whole case, the briefs below where Bartlett says no more occupational disease in hepatitis C cases, and therefore you can't have multiple dates of accident.
Well, but basically, again, they've accepted it here. And you're telling us that we have to recede from Michaels in order to reverse.
What I'm saying is you haven't, and implicit in their argument is that if, in fact, hepatitis C still is an occupational disease, or at least must be considered one for this case because they accepted it as such, then, in fact, you can have multiple dates of accident if you read the course of decisions from Michaels through McArthur to Sadaka. That's basically the implicit in their argument. That's why they made such a big deal in their briefs and at trial that hepatitis C is not an occupational disease based upon evidence that was presented in another case, a case decided 25 years after they accepted compensability. How can they backstroke now and say, no, it's not an occupational disease? And it wouldn't have been an issue. It would not have been an issue had it not been for the fact that they understand that you can have multiple dates of accident in occupational disease cases, whether we like it or not. And it's not really that different from hypertension or heart disease. Once you get hypertension, you've got it. Now, sometimes it gets exacerbated and sometimes it doesn't. All right? Well, sometimes it gets exacerbated to the point where you become incapacitated again.
But you
Perhaps you get a stroke.
You have no proof on the record in this case that your client's hepatitis C was exacerbated by his having gone back to work.
No, Your Honor.
And the burden was on you to demonstrate that.
Actually, what happened was it progressed to the point where it required treatment that did incapacitate him. That's what happened, Your Honor. And that the same thing can happen with heart disease. You can have a claimant who gets heart disease in the course of his employment and undergoes treatment or has a heart attack, is incapacitated for several months, like in McArthur, and then later on has another heart attack. It's the same disease. It's heart disease. That's what caused it, the heart attack. It didn't happen for no reason. It's the same disease. Just as a hypertension patient can have multiple strokes, and each one of those strokes is another period of incapacity or disablement, and therefore a separate date of accident, and the substantive rights available to that person as of that new date of accident are the rights to which he's entitled, and also the average weekly wage to which that person is entitled for each date of accident would be that in effect as of the date of that new accident, just like in Michael's. That's all I have, Your Honor. Thank you.
Okay, thank you, sir.
Thank you for the extra time. I'll be very brief. Your Honor and Todd were both reminding me about misusing the 8 years, and of course 25 years should have been 15. Regardless, our primary argument is that 92, if there's any date of accident, it's 92. He didn't go out in 97 because he had a new exacerbation of hepatitis. He went out because he was having new treatment for the exact same disease. But our secondary argument is that until...
What about his analogy to hypertension and multiple strokes?
Well, now, I disagree with him that hypertension is like hepatitis in the sense that it's a disease that you never get rid of. You can change your lifestyle and you can add medication. You can get rid of high blood pressure. People do that all the time. Now, maybe if you age and you change your lifestyle back or quit taking your medicine, then you'll have high blood pressure again. But hepatitis is a disease. It's different. But you ask, what is it about...
I'm saying 2 strokes. Does that give you 2 days of accident?
2 strokes? I would have a hard time arguing against that. Now, I might argue against it if it's the exact same cause. But 2 strokes, those are events. We don't have events here. We have treatment that the guy missed a few months of work for. But let me tell you why we thought Sadaka definitely.
Very quickly, Mr. Oxford.
This is a quote from the majority's opinion, talking about Michaels, but talking about Sadaka too. It is well settled in occupational disease cases that the date of accident is the date of disability, and disability is defined as the date the claimant became incapable of performing work in the last occupation in which he was exposed to the hazards, deteriorated to the point he was permanently precluded from working because of his disease. Now, that's from Sadaka. So there is certainly a implication, if not a finding in Sadaka, that in occupational disease cases, you don't really have a date of accident until you are to some extent, not totally, but to some extent, permanently precluded from doing that work.
Well, but the implication of that is that you succumb to an occupational disease, can't work for a year and a half, but because it's not permanent, you don't get any benefits.
Correct. Well, that's why that's a secondary argument only as to the 97 date of accident. But in fairness, it's a 92 date of accident. It's the same disease. We've paid him everything. He continues to work. He picks a period of time to miss a little bit of work 5 years after he contracted the disease to undergo a new treatment. Now, Michaels should be limited to its facts, a very permanent incapacity to do that work. Here, very briefly temporary, all benefits paid. We're just looking for fairness and justice, and we think that's what the legislature intended.
Okay.
Thanks very much.
All right, thank you. Thank you both.